Hi, my name is Peter Webster. I'm a lawyer with Carlton Fields in its appellate practice and trial support group. I'm here today with James Parker-Flynn, another lawyer in the appellate practice and trial support group, to discuss a recent Florida Supreme Court decision in which James argued the case on behalf of the petitioner and was successful in obtaining a unanimous decision for our client. The case is Alachua County versus Clovis Watson, who at the time was the sheriff of Alachua County, and the case number is SC 19-2016. As the court itself announced at the beginning of its opinion, the issue is how two statutes divide between a county and its sheriff the power to make changes to the sheriff's budget, specifically the sheriff's authority to transfer money within the sheriff's budget at a certain level of detail known as the object level. So James, I would suspect that most people have no idea what the term object level means and what object level transfers are. Would you tell us a little bit about what that is and how the case wound up in the Florida Supreme Court?
Absolutely, Judge Webster, and it's a pleasure being here with you today. So the object level distinction sounds confusing on its face, but really it's fairly simple. There are two chapters of the Florida statutes that set out the budgeting process for counties and then separately for sheriffs, and they work together. But the object level distinction applies really to all county constitutional officers who have to submit a budget. And essentially, when an officer submits a proposed budget to the county, they have to itemize that budget at various levels of distinction. And so at the very top of it, there's a function level. So for the sheriff, those functions are general law enforcement, corrections and detention, alternative facilities, and court services. And then underneath that, they have to itemize their budget at the object level. And the objects are personnel services, operating expenses, capital outlay, things along those lines. Now, below the object level, the county can request that the sheriff submit their proposed budget itemized even further into sub-objects. And those things are executive salaries, regular salaries and wages, overtime, and special pay. So the way we got to the Supreme Court is that in 2016, the former sheriff of Alachua County had moved about $840,000 of her budget that had already been approved by the county and appropriated to her. She had taken about $840,000 and moved it from one object to another. And the county did not like that. And so they filed a lawsuit for a declaratory judgment, trying to get a determination that the sheriff did not have that authority. And so the county proceeded to trial. They lost at the trial court and again at the First District Court of Appeal. And it was at that point that Carlton Fields was brought in to handle the petition for certiorari to the Supreme Court of Florida. And we did so. And as you noted, we were successful there and very happy about that.
Okay. You said that our client, Alachua County, lost at both the trial and the intermediate appellate level in the First District Court of Appeal. What was the basis for the First District's decision?
Well, there were a couple bases for the First District's opinion. And just to back up for a second, there are a lot of statutory provisions at play in this case, some under Chapter 129, which outlines the budgeting provisions for counties, some under Chapter 30, which pertains to sheriffs and includes budgeting provisions for sheriffs specifically. I don't want to get into really going through each one of these statutory provisions that were at play, but the First District had a couple of bases for its opinion, the majority of which were based on statutory interpretation. And so The first part of that was a provision under Chapter 129 that is referred to as the lame duck provision. Essentially, it set out some additional limitations on the ways that a outgoing constitutional officer can essentially spend appropriated monies under the budget. And without getting into too much detail, the First District read that under the expressio unius canon of statutory interpretation as essentially limiting any other authority that the sheriff would have, or limiting any other authority that the county would have to restrict how a sheriff spends its money. The First District essentially said, here is outlined the ways in which the county can restrict outgoing officers from spending. There's no similar provision for sitting officers, and therefore none of those restrictions apply. So that was one of the primary bases for the First District's holding. Additionally, there is a section under Chapter 30 which details the independence of the sheriffs. And the First District read that as an express acknowledgement of the power of sitting sheriffs, such that the county cannot then come in and say, here's how you have to spend your money. And so once you've gone through the appropriation process, sheriff, it's sort of up to you what to do with it. The county, you don't have the authority to interject into that. And then finally, the First District relied on a former opinion from the First District, Weizenfeld v. Dirks, which dealt with a similar issue and essentially said that under this case, county, you are prohibited from telling the sheriff how to use the money once it is appropriated. So those were sort of the three primary bases that we had to deal with in going to the Supreme Court and trying to convince the court that on each of those bases, the First District got it wrong.
It seems to me that I recall that when you argued this case before the court, it may have actually been almost at the height of the coronavirus pandemic. And I know you did it by Zoom because I recall watching it. I also know you got a lot of questions. Did you find any of the questions particularly insightful or helpful to you?
I did several of them, and we did get a lot of questions, which was fun. It's always fun to have a hot bench. But Justice Polston, when I was on rebuttal, asked me a question. He essentially asked, could the sheriff simply submit a proposed budget asking for one lump sum of money, not broken down in any way, shape, or form? And the answer to that under the statutes is clearly no. They say you've got to, itemize your budgets at certain levels and so forth. But the point of it, I think, was broader than that the court was seeing that essentially that was the sheriff's argument, that once appropriated, the sheriff just gets one big lump sum of money to do with what he or she wants, which, as we had argued in the Supreme Court, really negates all the various provisions that set forth the budgeting process, the approval by the county, the need to approve any amendments that add or subtract from the budget by the county, the need for public oversight. Essentially, the sheriff's position would obviate all of those provisions and just say, sure, we have to submit it one way, but once we get it, it's one lump sum. And it really told me at that time that the court was seeing our position pretty clearly, that that's clearly not what the statutes call for. And so we shouldn't read them that way to sort of lead to this conclusion.
The Supreme Court's opinion is actually a fairly long opinion for this court and spends a good deal of time in the context of discussing the First District's opinion, which it ultimately quashes, referring to the Scalia and Garner book on statutory interpretation. Did that surprise you at all?
I would not say that it surprised me. I think that we have a pretty good feel for the current construction of the Supreme Court, and we know that there's a lot of sort of textualist imperative on that court. We had not specifically cited to that book anywhere, but given the court's prior opinions in which that book has been cited, it seems to be a bit of a rising trend in their jurisprudence. So I don't think it was that surprising to see it in multiple places in this opinion. I think it just reaffirms that when you argue before this court, you're best suited, if you can, to make a plain language argument. And if you have the better one of those, better for you. If you don't, you should try to figure out how to make one because the court is really going to be going based on the language of the statute and trying to apply the canons of statutory interpretation in a way that sort of best fit that language.
And I think you're certainly correct when you say that it's fairly clear the court is relying more and more on a textualist approach to statutory interpretation. I recall when I successfully argued my last statutory interpretation case in front of that court a couple of years ago, I actually went out and bought a copy of the Scalia and Garner book and cited to it repeatedly in my briefing because, as it happened in that case, I had the better part of the statutory argument, just like you did in this case. So you mentioned in passing earlier the prior decision in Weizenfeld versus Dirks, which the court distinguished. It didn't overrule that decision. Can you tell us a little bit about what you think the potential impact of that Weizenfeld decision might be as it relates to county budgets going forward?
Yes, so Weizenfeld was a case that was, again, relied on pretty heavily by the First District as well as by the respondents, and we sought to distinguish it, and the Supreme Court agreed with us that it was essentially dealing with two different issues. Weizenfeld was dealing with the county's ability, after it had appropriated monies, to refuse to release funds to a sheriff because it didn't like the way he was going to spend those funds at a level which we would now call sub-objects. And as we made clear to the court in this case was all about object and function level transfers, nothing below. We never contested the sheriff's ability to use funds at the sub-object level as he or she sees fit. And so really, we didn't think it was in any way restricting on our current situation. It is one of my favorite things about the work that we did on this case, though, which is that we went and tracked down some of the briefing from that case and had the sheriff's brief from that case from, I think, 1978 or 79, in which the sheriff made that very clear, said, I'm not challenging my ability to move monies around at that level. In fact, I would have to come to the county if I wanted to do that. So it really helps sort of make our point that these were distinctive cases. And so as it affects counties currently with budgets, I think it can be read in tandem with this case. The county constitutional officers have to itemize their budgets at the function and object level, and below that, if requested by the county, at the sub-object level. And the object level is really the line of demarcation between the sort of county's accountability as the taxing entity and the spending entity and the sheriff's authority. So above that level, once the budget has been approved and authorized and gone through the public review process, the sheriff can't move monies around at that level or above without coming back to the county, which it can do in a number of different ways. But below that level, the sheriff retains authority to use the money as he or she sees fit. After all, it's already been approved for a specific object, so moving it within the sub-objects doesn't really cause any problems. And should the county try to come in after the fact and prohibit a sheriff from doing that, that would violate the statute. So I think they can be read in tandem to say, in the one instance, here's where the county's accountability and authority is over the budgeting. And in another instance, here's where the sheriff's is.
I think we can probably both agree that the court's decision turned primarily on statutory interpretation. Given that fact, what do you think the most important takeaways are from the court's opinion in this case?
I think there are a couple of things. I don't think the court necessarily broke new ground in its opinion, although, as you noted, it was a very long opinion and very thorough. I don't think the court necessarily broke new grounds, but it did reiterate a number of points on statutory interpretation that are important to the court, exhausting all textual clues before doing anything else, reading statutes collectively in a way that is harmonious. The court made several sort of musical references in its opinion to harmonious reading of the statutes, and providing some language that going forward, again, not necessarily something new or groundbreaking, but very clear and very easy for someone to take in the future and cite to as, here's the best, most recent example of the court's thinking on how to interpret these statutes. And the second takeaway in relation to that is sort of expressly related to the court's discussion of the expressio unius canon, and it's sort of warning about the limitations of that canon, not to read it too broadly, certainly not to read it in a way where you're basically pitting one statute against another such that you're negating express statutory provisions in favor of, at times implied provisions. So I think on that one, it was maybe a little bit more clear than it had been in the past that is a canon that has some real limitations, and you really have to have a strong basis for it, and at the same time not be sort of conflicting with the other canons of statutory interpretation. That was one of our arguments before the Supreme Court, was that the First District relied almost exclusively on that canon and sort of ignored the others about reading these statutes in concert. And the Supreme Court was very clear that that was something it was not going to allow.
And I guess really there are 2 points we should keep in mind here with regard to textualist statutory interpretation. The first is, and the court's told us this many times now, that if the language of the statute is clear and unambiguous, there's no reason to resort to canons of construction. And the second is, and I think a lot of practitioners perhaps tend to forget this fact, and it is a fact, that the canons of construction, almost every one of them has at least one equal and directly opposing canon of construction. And canons of construction are very susceptible to being used to justify results that a court might want to reach on other grounds, rather than legitimately providing a means by which to get to a result. So this opinion, I think, also makes all of that very clear, and that's probably a good thing as well.
Yeah, I agree on that, absolutely.
I think probably we've covered this, unless there's anything else you want to talk about.
Not much else I'd want to cover here, other than that I think that, like you said, this is just sort of reiterating the court's current stance, and it's critically important, as always, that practitioners sort of understand the court to which they're arguing. So know your court. Make sure you know the arguments that are going to work for your court. In the Florida Supreme Court right now, those are a lot of textual-based arguments if you have them. And if you have the plain language as your starting point, that's always sort of the best position to be in. So,
again, great victory. Congratulations. And it's always particularly heartwarming when you're the advocate and are able to get a unanimous decision from the highest court in any jurisdiction.
Absolutely.
James, thank you for providing us with your insight about this decision. If anyone would like to learn more about the decision or about Carlton Fields' appellate practice and trial support group and what we do, please visit carltonfields.com, and also stay tuned for subsequent episodes in our podcast grouping.
This podcast is intended for general information and educational purposes only and should not be relied on as if it were advice about a particular fact situation. The distribution of this podcast is not intended to create, and receipt of it does not constitute an attorney-client relationship with Carlton Fields. Thanks for listening.